Well, good afternoon, everyone. Thank you for joining today's webinar on choosing, building and protecting your brand. Sorry for the little late start. Turns out there was a problem with the link. So thanks for persevering and joining us now. I'm Georgie Collins. I'm a partner at Irwin Mitchell. I head our IP and media practice and have been looking after and protecting brands both domestically and worldwide for almost 30 years. Just a couple of points of housekeeping before we kick off. If you have any questions, please can you pop them in the Q&A chat function. The session will be recorded and it will be sent round to you afterwards. Please can you also complete the feedback survey, as your feedback helps us tailor our events and content to you. And lastly, if you think this session is useful but you'd like to have a deeper dive into some of the issues I'm going to talk about, and use some case studies around, then please pop that in your feedback too, and we can arrange potentially a workshop virtually or in person, depending on where you're all based. Next slide, please. So choosing, building and protecting a brand. What we're going to cover in this session, we're going to explore how to create a brand that resonates, choose a brand which is informed by what you can and what you can't protect, essential checks to carry out before you use and then seek to register a brand, protect it, and how to avoid some of the common pitfalls that undermine your brand, can be costly, and I tend to see sadly day to day. This webinar is intended to give you practical insights and strategies. It's for all businesses, large or small, domestic or international. So whether you're launching a new venture, product or service, or you're well established and just looking for insights and tips, hopefully this will have something for everyone. Next slide, please. So what is a brand? You will get different answers depending on who you ask, whether that's your legal folks or your marketing people. I decided to pop it into Copilot and it gave me 3 different suggestions. And I think those on screen describe broadly, generally, actually what a brand is. So it's more than just a name or logo, but it certainly includes those. Certainly in the world I live in, the types of clients that I work with, the brand is the sum of all expressions by which an organisation, an individual sometimes wants to be recognised. It's certainly the lifeblood of a business and its identity. It's your customer experience, a story, and often a set of associations that help differentiate you from your competitors. It's also one of your most valuable assets, if not the most valuable, and it can be protected in a number of different ways to various advantages, which I will chat through. Next slide, please. So choosing and building a brand portfolio. So brands manifest themselves in many different types of forms in terms of how they can be protected by varying IP rights, whether registered or unregistered. So typical brand associations are names, colours, packaging, logos, straplines, which are all protected, can be protected through a combination of different IP rights. And the goal, the end destination, is to create a consistent and distinctive identity that consumers can associate with your product or service. So I've picked on here Coca-Cola, recognising it is a global household brand with significant brand protection budget, but I thought it was a useful example in terms of showing how the different naming rights can be brought together to protect that overall brand where it's coordinated. And these rights, are a combination of what we consider to be registered trademark rights, design rights, but what we would otherwise refer to as common law rights, such as, for example, domain names, company names. And here you can see the consistency of how the name is used, how it manifests itself in terms of a stylized form, through to how it may look as a product, which you see as a design right, and as a copyright, which is more in relation to a media campaign which uses that brand. So understanding what types of rights can help protect your brand in whatever way it's manifested is kind of critical to try and build this ring of steel around your brand, such that you don't just rely on one right, which may let you down, but in fact you avail yourself to a myriad of them, which really collectively enforces that protection around your brand collectively. So I'm going to talk a little bit about layering your brand rights. Next slide, please. So in addition to the examples I've given with Coca-Cola, I've tried to illustrate different aspects of a brand or a product of service, or how it manifests itself, and how varying different IP rights can protect aspects of that holistic brand. So registered trademarks cover things like names, logos, slogans, and more. But in order to secure a trademark, it's got to be distinctive. Descriptive is something which would be a bar to registration. Trademarks are also registered according to 45 different classes of goods or services. So you've got to be specific in terms of what you're looking to protect. So it may well very be the case that there are other trademarks which are the same as yours or your intended mark, which could happily coexist with you, albeit in relation to different classes. So some examples of that would be Ritz. So we've got Ritz hotels, but from what I remember when I was a child, there's Ritz crackers. Happily coexist using a Ritz brand, but for very different products. Polo mints. Polo is the name of a car. Apple, although those two came to blows a number of times in relation to Apple Records, and then in terms of Apple, of what many of us will use day to day in terms of our phones and gadgetry. And I've sought to illustrate here too, in terms of what those trademark rights look like in terms of registration. So for example, here you've got the slogan, "Every little helps." You've got sound marks. So for example, the MGM lion roaring is a registered trademark for a sound. Other examples include the direct line telephone jingle that many of us will have heard on the television. And the Dulux dog barking is also a registered sound mark. Colour combinations. So these have become particularly prevalent over recent times. So what you see there is the Tiffany blue. BP has a registration for the particular colour green that it uses. And these are often effective brand strategies when used in combination with a name or separate to it. So say, for example, someone was to use the Tiffany blue in relation to high-end jewellery, but didn't use the word Tiffany. Would that still be a problem? Likely, yes. But without registered protection, registered trademark protection, could that be difficult? Yes. You see the logos on there in terms of illustrating how you can present that stylized logo with a form of apple. And something which is becoming more recent is certain circumstances where individuals are registering their face as a trademark. We're seeing this in particular in individuals who are well known, so particularly in the realm of media, sports personalities, but we've also seen it where it has been registered individuals less known. And this is all part of protecting an individual's brand, where using other IP rights may actually be difficult. So say somebody takes a photograph of an individual, the person who's the subject of the photograph won't necessarily own the copyright unless they've got an assignment. It will be the photographer. So trying to enforce any misuse around an individual's likeness in how they look, perhaps in combination with promoting another product, can potentially be difficult. So we are seeing this sort of movement in relation to people registering their likeness. This may also be as part of an attempt to deal with deep fakes. And in relation to takedowns, particularly around websites, one of the things that can prove to be very effective is having a registered trademark to secure those takedowns. And perhaps that's one of the things which is starting to drive some of these trademark applications and successful registrations in relation to a person's face. Design rights. So design rights protect the appearance of a product. They're not categorized according to classes compared to trademarks in terms of their enforceability. And they protect the appearance, shape of an article, but also the combination of features. So it can be the whole of an article. You see a gin bottle on there, Or it could just be some of the detail which appears on that particular article, which is the kind of real genus of what you want to protect. They protect a whole range of of articles, whether that's the whole or a part of it. So, for example, there are registrations for car tyres in terms of the imprint that you see on them. You'll see there's a fabric print. So design rights are commonly used, particularly in the fashion industry and in retail, where one wants to protect a particular aspect of a product. The overall product itself may not be original, which is a threshold for protection. So say, for example, handbags, which is something I've dealt with a lot of protection before, unless it's an unusual shape handbag. Often one of the things the brand owner will be looking to protect is aspects of that handbag. So perhaps the placement of the buckles, studding, the ornamentation, the surface decoration, and the fabric pattern. So the pattern which is illustrated here is one owned by Louis Vuitton, and who regularly files designs and seeks and obtains registrations in relation to new aspects of its bag collection and other articles. And then design rights will also protect more functional items. So it's not just aesthetics, but for example, particularly in relation to toys, screws, so across the whole board. Copyright doesn't, so I should also say that in relation to designs, they can be registered or unregistered. Registered protection lasts 25 years, unregistered protection lasts for 3 years. Compare that to a trademark, which can potentially last indefinitely, so initial period of 10 years. But providing you renew your trademark and you use it according to your registration, you have potentially a perpetual IP right, which is extremely valuable. Copyright in the UK can protect a whole combination of what we've seen with those trademark rights. So particularly logos, potentially types of product packaging, design features, but it also protects, I've given an example there, in terms of what's on your website content. So your collateral, your marketing materials, videos, podcasts, illustration here of what we promote, and the stylization of your logo. No requirement for registration, and typically for most of the rights there are some differences, but a long-running right too, so 70 years plus the life of the creator. But what's the real strength in looking at these core IP rights is trying to bring them together and understanding exactly what it is and how you best protect it, so that if you come to an enforcement perspective, you don't fall short on one type of criteria compared to another. So to give an example of that, I think the supermarket copycat cases, as they're often described, illustrate that some of the distinctions, particularly between, say, trademark rights, trademark registrations, and design rights. So many of us will have followed with interest and amusement to some degree the debacle between Aldi and M&S in relation to Colin the Caterpillar and Cuthbert. And that case, which was brought in relation to trademark infringement by Marks and Spencers, was ultimately resolved, but it was brought on the basis of trademark infringement. And going back to the issue which I'd mentioned before, one of the issues in relation to satisfying a claim for trademark infringement is to show is a requirement to show a likelihood of confusion with consumer. And it has become sort of well-trotted authority in terms of the various decisions concerning sort of supermarkets, such as, say, Aldi or, say, Lidl, that the consumers aren't confused at all. They know exactly what they're buying, and they will often recognise that the get-up of the packaging looks a bit similar, colours are similar, some of the swooshes or indicia which are on those products are similar, but the names are not. And it's often the names which are registered or a specific type of logo. So more recently, there's actually been a couple of successes around for brand owners in relation to, particularly in relation to Aldi. So Thatcher's cider. So one of the images which you'll see there on the trademark slide is they hadn't just registered Thatcher's, they hadn't just registered, for an example, an image in relation to the fruit, but they had registered as a trademark the combination of the packaging, including the can, but also the external packaging, what we call the get-up of it. And that was extremely well, it's what was successful in their claim against Aldi, because Aldi hadn't used the trademark, the brand name which they used, and they'd altered things, but it was considered sufficiently similar in terms of the registered trademark which Thatcher's had for the overall brand packaging. Then looking back to Marks and Spencer's, who were successful last year against Aldi, not in relation to Caterpillar cake, but in relation to a liqueur gin, which it brought out at Christmas time. And it brought out a number of bottles which had Christmas sort of decorative associations to them, but registered them as designs. And they succeeded when Aldi brought out similar product, used a different brand name, so wouldn't have infringed on any potential trademark rights, but was seen to be sufficiently similar, creating the same overall impression by virtue of Marks and Spencer's design registration. So one of the tricks here is understanding what your products are, what your services are, and how you can protect them, and you can build these different rights so that you don't fall down enforcement on one particular right or another, and seeing how the combination of a trademark registration, design rights, copyright interact with each individual aspect of your brand. And if you're able to get to that stage, you can have a really defensible brand where you're not let down because the criteria for enforcement in relation to one right isn't going to assist you. So layering those rights is really, really important in terms of building that valuable brand that's going to stop encroachment on your rights. Next slide, please. So essential checks before you set out. And this is whether you're well established or you're looking to embark on any new product or service. So a conversation which I have at least daily, often more than daily, with businesses is just because something is available to register does not mean that you are able to use it without infringing on someone's rights, or able to register it, whether it's, say, a trademark or a design. And I see all too often businesses, and they're not just startups, they're often well-established players, will skip essential checks before launching a brand. So they will go ahead, register a company name, secure the domain names, social handles knocked down, and start building a website and marketing materials, and are then forced to rebrand. And one of the questions I'll always say is when someone comes to me and says, oh, we're looking to launch this, can you just register the trademark? And I'll say, well, you should carry out some clearance searches first. Oh, I've had a look-see on Google, it looks fine. And my answer to that would be, would you buy a house, a car, or a business without carrying out any due diligence at all? Would you make that investment? No. Is typically the answer. So why would you do that with your brand, which you're going to invest in? This issue around clearance searches and carrying out your due diligence is becoming more and more important, not just in terms of the safety of a brand that you are going to adopt, use and build value in, but particularly important for investors. They want to know that you've done your due diligence, that your brand is a safe investment for them, and it's not going to turn into some sort of unwarranted cease and desist letter, or actually even worse than that. So we always strongly recommend that before using, let alone registering, you carry out searches which will cover both identical and similar names, because merely because a name is not identical to the one you have chosen, and that's whether it's identical visually, orally, conceptually. Those nuances matter. Is it identical in a different language when it's translated, and particularly in a jurisdiction you may be looking to protect? Those factors weigh into it too. So carrying out searches of both identical and similar names, which includes searching trademark registers, but also what we call unregistered common law rights. So that would extend to things like company names, domain names, social media handles, general internet searches to assess if a brand is being used by a business, which could lead to them having common law rights, even if it's not registered. So another misconception is, well, someone hasn't registered the trademark, I have. That's not how it works. In the UK and indeed many other countries, a party can have been trading without having registered trademark and be able to stop someone else who applies for a trademark registration that could conflict with its rights and its activities. So clearance searches are critical, and will give you that assurance going forward, assuming that they're clear, that there's no skeletons in the closet. What they do secondary, so you've cleared the path for your use of a brand. The next thing is ensuring that if you want to secure a trademark registration, you need to understand what the state of the trademark register is. For conflicting marks, trademark applications and registrations are soaring because of the value of brands. Trademark registers across the world, not just in the UK, are becoming more and more congested with more marks. And that means there's even greater scope for conflict and the need to kind of assess what's on the register, what might be close to you, and what you need to dart around. So for the purposes of preparing any trademark application, you need to be mindful of what else is on that register that either the trademark office in a particular country may cite as an objection, an office action to your application, or a third party may file an opposition, which potentially then leads to an even broader dispute. I regularly have clients who'll say, partly because of in the UK, getting a trademark registration is relatively straightforward with the UK Intellectual Property Office. There's a lot of self-filers of, I filed the trademark myself, no one else had an identical mark, I'm free to use it. And someone pops up because they're notified by the trademark office of a similar application. And the client is then potentially stymied. And possibly, had it not applied for an application, it would have gone under the radar. But by not carrying out those checks, puts itself at risk of being challenged, both in relation to its use, which might have got away with until now, but also in relation to seeking a trademark registration. Understanding how trademark offices operate internationally too is important if you're looking to take your brand outside of the UK and into other jurisdictions. So subject to certain treaties, IP rights are dealt with typically on a jurisdiction by jurisdiction basis. So just because you've applied for a trademark in the UK doesn't mean you have protection in other jurisdictions unless you apply in those too. And those other offices have different practices, and the approach to securing a trademark registration is quite different. In the UK and EU, the procedure is fairly administrative, although can become litigious if there are oppositions with third parties. But other jurisdictions, particularly say the US, it has much more of a litigation flavour about it. So we guide clients in terms of where they're looking to get protection, because what they may experience here will be very different in another jurisdiction, both in terms of the procedure but also the cost. Next slide, please. So looking at your brand strategies, so key is what to protect, and that involves, sometimes it'll be straightforward, you might only have a name, might just have a word, but likely your overall brand will extrapolate just beyond the word. And it's sitting down and looking at, for example, those rights identified before, so registered trademarks, design rights, copyright, how those different rights may protect aspects of that brand, and being aware of that, and where possible, securing registered protection. But part of it is being savvy and understanding what the IP rights are that fundamentally protect your product or your service. Where to protect? So one of the comments I'll have is, I want to protect my brand globally. I protected in my career 3 brands truly globally, and it requires a very significant budget to protect a brand in every single trademark office across the world. But in today's in the international and particularly digital environment which we live in, it's very rare these days for a business that I come across that is just looking to protect its brand, say in the UK. It's looking further afield, either because it's looking to do business ultimately in a number of other jurisdictions. Perhaps it wants to protect its brand from a defensive perspective, and perhaps there are other jurisdictions which pose a threat in terms of the procedure which goes on in those countries of other third parties who speculatively seek to register other people's marks when they've seen them register them in other countries. So it's important to consider where you may need to protect your brand and have a strategy and a timeline around that and how you may approach it. When to protect? So if you are looking on a particularly new brand protection project across a number of jurisdictions, if it's something which is going to be high profile, looking at the timing is really crucial, so that you don't basically have a spoiler moment. And I've had this in a couple of the big brand protection programs which I've dealt with, where we have orchestrated the filing of trademarks where an initial trademark application might be filed. Perhaps it might be filed in a jurisdiction which is slow to publish applications, and there is a system in relation to trademarks where you can claim priority. So you file a trademark application in a country which has a priority system, and within 6 months you can claim priority from the date of that first filing in another jurisdiction. It's a really useful mechanism when, particularly if you're working to a budget, you don't want to file applications in multiple jurisdictions straight away. You want to see how the examination process might run out, but also you are building a bigger brand campaign around that. So in some circumstances, brand owners will file in a jurisdiction which is slow to publish, which gives them a little bit of time, whilst they then use that priority filing for other jurisdictions, and then they will seek to register company names, domain names, social media handles, and have that all planned. One of the things where we see it goes wrong is the registering of a company name, or particularly a series of domain name on social media handles, which can tip someone off about the launch of a new brand, particularly if it's with a well-known brand owner, which causes that real spoiler moment. So timing is key. Who will own it? Again, in the context of if you're trying to keep a lid on something in terms of what might be a high-profile brand launch, you don't necessarily, you may not necessarily want the entity owning it as Coca-Cola, because if people may have monitoring searches and they're looking at brands in terms of the applications they may be filing, that would show up. So we'll often look at different business entities where there may be a high profile launch, which will be the owner for those applications, whether it's trademarks, domain names, company names, whatever it is, in the short period of time, so as to avoid that moment of disrupting the splash that the client will want to have. So coordination is key around all of that piece in terms of what you're protecting, where, and your timing relative to the success of that launch. Next slide, please. So brand monitoring and policing. Often clients will get to a point where they've got the registration. It's kind of like, right, job done. Not so, because looking after a brand isn't just about securing a registration. It's about monitoring it, enforcing it. So little point in spending resource on securing trademarks if actually you're not going to monitor them and enforce them. And there are a number of brand monitoring services which businesses can avail themselves for, and they're really valuable in terms of essentially being your eyes and ears of what might be happening with your brand and what encroachment there might be. So, for example, Trademark Watch monitoring services. So these are services which you can have just the UK, you can pick jurisdictions, you could have a global trademark monitoring service for which you will identify a particular brand. So say Coca-Cola, going back to one of the initial examples, identifying the countries where you want that watching service, and you will be alerted when there is an application which is identical or similar in relation to that mark. And the reason why it's important to really consider these services when you've this type of service when you've invested in a brand is some trademark offices, but not all, will notify you if it receives an application which it deems, or its algorithm deems, is similar or identical to your earlier right, whether that's an application or a registration, but not always. And correspondence goes astray, and sometimes it might take longer than it should. And particularly in some jurisdictions, the period for opposing a conflicting trademark is short. And by the time you receive a notification from a trademark office, even if they do notify you, it may be too late. So having this trademark monitoring service is really crucial to seeing what may be going on in the marketplace or not in relation to your trademark. Again, I mentioned before how important clearance searches are, particularly to investors, in showing that you've done your due diligence. Often when we have dealt with the sale of a business in particular where the brand has been core, one of the things that has been looked at is what monitoring services does the client have, does the brand owner have, so as to understand what the strength of its brand is, the defensibility, and has there been any encroachment on it. So also mentioned on here, other monitoring services, so domain name watch notices. The sort of heyday that we used to have of what we call that domain name hijacking, so people going and registering the well-known brands of other businesses either about to launch, that spoiler moment, or otherwise just because they'd expect to be offered a bit of money to go away by the brand owner, is less prevalent. There are still many disputes, but what we see now often is the registration of domain names which are very similar to a brand name, maybe a typo, an extra I or something like that in the name, which are often the sign of more nefarious behaviour, often the sign of a potential phishing attack. And those names just sit there. So we find that in addition to the sort of IP internal clients that we may work with, we often are working with the IT CISO teams in relation to them having these domain name watches in place, which will tip them off in terms of the registration of a potentially conflicting mark, even if nothing is appearing on its server, for which it will have other defence mechanisms, but to be used in combination with that. Company name watches, similar. I mean, that is often one of the first signs of a potential conflict, and partly because it's in the UK, it's very easy to register a company name, relatively cheap, instant, and clients would just assume that a variant of a company name, there might already be similar names, but if you put holdings in the middle or something like that, it differentiates it from another mark, and there's already lots of them anyway, is often one of the reasons given. I think that's fine. It's back to the well, it was available to register, so it must be okay to use. So those company name watches, and again, they can be monitored on a domestic basis or on an international basis. And then there's other social media handles which can also be monitored. So you can take this to whatever degree that you want, but I would also say if you've made the investment of getting a registered trademark, absolutely have a trademark watch service, and you absolutely should look at a company name watch service too, in order to have those eyes and ears of what may be going on with your brand. Next slide, please. So having a disputes strategy, this is usually the unhappy conversation that I start to try and have with clients, which is at some point there will be a dispute. For bigger brands, that they kind of see that as a business as usual, whether they're going to be the aggressor in that or perhaps they're going to be fending people off. But smaller businesses, it's a difficult conversation because that's not where they want to be. But even if it's fairly low level, so somebody registering a similar company name, somebody's registered a similar trademark, which could be resolved through some form of negotiation, asking a party to withdraw. It's actually important to sit down and understand what your tipping point is. So what would cause you to want to take action, and how would that look? Because depending on the nature of your business and your audience, your consumers, will inform how you want to pursue potentially any action and that stance that you will take. So having that strategy articulated in how you would deal with things. So for example, if you discovered somebody had registered a similar company name, would you write to them yourself, or would you instruct a lawyer? What sort of tone would you want to take? What's the form of escalation in relation to how you would deal with these disputes? Is it something you want to squash straight away, or again take a more gentle approach depending on the circumstances? With clients where, particularly if they're in the retail consumer space, and it is likely there are going to be issues, and it is likely that people will want to imitate them or copy them, is to have a type of escalation procedure of, sometimes if they've got an in-house team, they send a letter first, then we get involved, and there's an escalation point between those letters and what comes next. And then the question is about, when would you actually take action, and what type of action would you consider, and what could you actually afford or not? And having that articulated in a plan, so that actually when something much more serious does happen, you're not scrabbling around, and you have a go-to plan in terms of, well, we identified this type of scenario as being serious and something that we wouldn't tolerate, and this is the go-to plan for it. Having the internal teams on board, particularly your marketing, web folks, product development, them being your eyes and ears in the marketplace of what's going on, and understanding what your brand strategy is also really important in dovetailing what that enforcement may look like, and how you bring people together, get information in terms of what sales have been, where have those sales have been, what does it look like that's been sold. Making use of online takedown systems, which can be very effective and is something that clients will often do directly, or if they're a very sizable brand selling product on, for example, eBay or Amazon, there are vendors out there who have automated tools which in certain quarters can be actually very effective in terms of getting other product taken down. Next slide, please. So looking at other enforcement mechanisms too, and again, this is particularly in relation to products, but using other channels. So particularly if you're moving products across different jurisdictions, so using customs and enforcement, the training which goes around those customs enforcement authorities, trading standards, who again can be, you know, your eyes and ears in terms of how you deal with the movement of your product, and deal with that, and then look in the end to what the escalation of that legal action could be, and how you could avail yourself of other dispute forums. So, for example, it's not always court proceedings. There are some relatively efficient and cost-effective tribunals within sort of the IP world that can get you a good resolution. So, for example, if someone's registered a conflicting company name, you sent them it, and they're using it, they've registered it, it's very similar to yours, they're refusing to change it. The company names tribunal is a very effective forum for trying to resolve those disputes, providing it satisfies the criteria for what's considered to be an encroachment. Similar with domain name disputes, that's a bit more complicated, the company names tribunal, but again, a different forum which certainly is much more cost effective than, for example, having to resort to legal proceedings, and particularly where you have parties who perhaps registered rights, say, in relation to the domain names which are in different jurisdictions. So looking at all those dispute resolution forums and thinking about how, when you're thinking about how that dispute might arise, what might you avail yourself to, how would you use that, all go into the broader dispute strategy and your overall brand protection, enforcement, and building that value in your brand. So I think that brings us to the end of our session. So thank you very much for joining. Are there any questions in the Q&A? Not sure I can see any. No, I can't see any. Well, thank you for joining us. If you do have any questions on reflection, you'll have my contact details. Feel free to message, and please do complete the feedback survey. And if this is a subject which is of interest to you and you'd like a deeper dive, then let us know that too.